Okay, great. So, thank you and welcome to our session addressing sexual harassment in brewer environments, fostering respectful workplaces. My name is Danyelle Semjonovs. My slides were working just a second ago. Okay. Betsy, I didn't ask you for a photo.
That's okay. The
But
old
you did say
fashioned is
that
my
you like
favorite drink,
whiskey.
so you nailed it.
Yeah, yeah. So, okay. My husband's too. Before I got pregnant, when I could drink wine or drink, period, I was a Merlot drinker.
Oh yeah.
So anyway, my name is Danyelle. I'm a senior attorney here at Whitcomb Solinsky PC and Beer Law HQ, which is run by Brandon Solinsky. And we're going to give a presentation today on some general sexual harassment issues, definitions, legal framework. The description is there in the session introduction. I was telling Andrew before we started this that I wanted to introduce Betsy, but most of the people who are going to be attending this session already know who Betsy Lay is. It's more of an introduction to me. I am, like I said, a senior attorney at Whitcomb Solinsky. I have ample experience in employment law, employment litigation, and sexual harassment and sexual assault. I was a sexual assault attorney up in Washington State for a few years before moving back to Colorado. So I don't want to go through every single session or every single section at the outset of what we're going to be getting into. I just want to start with a brief overview of what we're going to be talking about. Again, that's going to be the definition of sexual harassment. What does it mean colloquially? What does it mean legally? And that will probably vary from state to state, but there are some general federal definitions of sexual harassment that you should be aware of. So that's why we're here, to give this super basic instruction and training on sexual harassment, but specific to the brewing industry. And that's why I'm so grateful to have Betsy here, who will be able to shed some light and in my opinion, based on our conversation yesterday, some true best practices for the industry. So with that, I just want to highlight a couple of these sections in the overview that we will probably focus a little bit more heavily on are the legal framework and the prevention and intervention / best practices. Another one that we should probably highlight in light of recent events in the last 5 years or so is supporting victims, because we can't stress enough how important it is that leadership make sure that the brewery environment builds confidence in victims, not just to report, but knowing that there will be an adequate response after they do report sexual harassment at their workplace. So obviously, the reason that we are here, you all know way more than I do about Rep Magnet and how the Me Too movement impacted every industry, but especially the brewing industry, starting in 2017, but really ramping up in 2021. So I applaud the brewing industry for creating this platform, creating these sessions on harassment and how to respond, and listening to people who have made complaints, and listening to survivors of the sexual harassment and actually doing something about it. And not every industry does that. So I applaud you all again. Betsy, did you want to say anything by way of introduction before we get started?
No, you're doing great. So I'm just gonna wait for you to tell me when you need me.
Thank you.
Yeah.
Okay, sounds good. Okay, so we're going to first start with defining sexual harassment. I'm so sorry if you can't see that. I will read it to you, not all of it. But you have 3 broad categories of sexual harassment. The first is verbal. That's going to be your name calling, your sexual jokes, really any words or comments of a sexual nature that can include comments about a person's body or physical appearance, general things that you hear. Sometimes, and the courts will differentiate this from, and something that's more egregious, like a slang term or calling somebody completely out of their name versus general teasing. And we'll talk about that a little bit more when we get into the legal framework, but verbal is exactly what it sounds like. These are words and comments primarily. Nonverbal, these are examples that you have heard about and you may have seen in your workplace. A lot of times they come up in offices where somebody might have a pornographic photo hanging up in their cubicle, or they might send an email that is sexually suggestive. I have personally had cases where someone got a text from a coworker with genitals as in the photo from in the text. Those kind of cases are what the court might consider to be egregious, where it's just so explicit. Other times you have cases. There's a recent case. I want to say it's in Colorado, where these guys were in a warehouse and listening to some derogatory and sexually explicit music, and it offended some of the women in the warehouse. And the courts just decided that that was sufficient here in Colorado to state a claim for a basic prima facie case for sexual harassment. So those are some examples of non-verbal harassment. Finally, the last one, physical touch, is pretty self-explanatory as well. That's when you're talking to somebody, touching someone in an inappropriate way, and specifically that it's against his or her will. So these are the colloquial definitions of verbal, nonverbal, and physical sexual harassment. So when I was talking with Betsy about this yesterday, we were thinking about how those basic definitions of sexual harassment show up in the brewery. And she gave me some not specific examples of sexual harassment, but how they can play out in a brewery. And that's when you have, situations with bar space, when the bar space is cramped and people are working in very close proximity to each other. So you might have somebody graze a buttocks or something like that. And it might be expected, it might not be expected, but it's certainly more common than in an office place, for example, where you have people who are working on completely different sides of a large building. The lighting is different. There's alcohol that's involved. There are one thing that Betsy mentioned, professional and friendship lines being blurred, especially when you have the alcohol involved. So this environment makes the appearance of sexual harassment, at least, a little bit more prevalent or available. Betsy, I wanted to know if you could share a little bit about how sexual harassment might happen in the bar, and reiterate a couple of things that you were sharing with me yesterday about staff training and industry events and how sexual harassment happens in those situations.
Sure. We hold at Lady Justice, we do part of our staff training is safe bars training and certification from safe bars in Washington, D.C. And we just had we do a recertification every 2 years as a staff. And so we just had ours last month. And one of the things that we talked about in that training was how sometimes it falls under more of that verbal, non-physical harassment, but some examples are, you're trying to get somebody to pay their tab, but they're sort of holding that over you to get your phone number, right? So they might think that they're being fun and flirting, but the bartender just wants to close out their tabs, get paid and go home. So like one of the examples was, somebody who is using the time it takes for them to tip and sign their tab and close out and leave the bar as a way to get information from the bartender. So in a like maybe a joking manner, saying like, you know, I would love to get your number. I'd love to know more about you. And very clearly waiting to sign their tab until they get that information. So that can happen over a bar between a patron and a bartender. So that happens. Tipping is a really interesting way that we see power dynamics in play. And then also, you know, the model of, you know, management versus bartending, there is quite a hierarchy there in terms of, you know, being able to, if you don't have a system in place that has equitable ways to tip out, very clear lines and boundaries, there could be some means to hold power over your staff in that way too. But we were talking specifically about how patrons might be able to do that. And so, yeah, we do staff training. It's really important to do, you know, regular staff training and, you know, just making it a part of company culture to be on the lookout for signs of harassment. And I always talk about, in the same way that you might do a tip certification or a safe serve certification for your staff, include sexual harassment certification as part of that means. It's another layer of awareness, another layer of safety, so that your staff can be aware to look for the signs, just like they know how to look for the signs of somebody who comes into your bar drunk, somebody who's been overserved. They can also look for the signs of harassment playing out either, you know, patron to staff or staff to staff behind the scenes. And then we also see this.
That's when,
yeah, go ahead.
No. When we get into some of the prevention, the intervention, and the best practices, the training is absolutely going to be something I would love for you to reiterate in how you work in sexual harassment into the training. I wanted to go back to the patron. Even though this particular training we're talking about, really about the employer liability and employee involvement, where you have those different dynamics, like you said, the different hierarchy. Sometimes you do, as the bar owner, have to be aware of, especially a regular patron who is coming in and consistently doing this to your staff. Because if it becomes enough of a problem or a consistent of a problem, and when we talk about the legal definition of sexual harassment, we look at frequency, we look at severity, you might become liable in that situation for not doing something. And we'll talk about what that something is later. But when you're talking about a patron, of course, the employee as a civil person, or as a person in a civil society, they also have the civil code. So they can always go to the court and ask for a protection order from this person, that they stay away from their place of establishment, especially in those situations where, you know this patron by name, where this patron lives, because they just walk to and from their home to the bar. They basically know where everything is in the establishment. They know everybody on your payroll, your roster. Those are kind of some facts that may blur that line between who you're responsible for preventing that sexual harassment from. But back to these specific definitions or colloquial definitions of verbal, and nonverbal, and physical sexual harassment. I love what you said, because for the patron who's tipping, they may not say something sexually explicit. So if it is them withholding tips, they might have their checkbook out, or they might have the clipboard and the receipt for the payment, and maybe they just bring it close to their chest and say, "Hey, can I get your number?" Yeah. I think those two, the verbal and the nonverbal action of bringing the payment close to your chest and almost looking like you're physically withholding this, is a good example of how those kind of work together to paint the picture of the sexual harassment. And sometimes just the dynamic of it being male to male, or male to female, or what have you. can shed some light on whether or not that's sexual harassment.
Mhm.
Okay, did you want to say anything about industry events really quick before we move on?
Yeah, just that, at industry events, I've heard so many. That's where I see a lot of, verbal, nonverbal, and physical can all happen very easily at a beer festival. And it can also happen very easily between patrons, but also you might be at a tent next to a neighborhood brewery. And so there's a lot of mixing of different businesses and different management and who's in charge of what and where. But at a festival, people tend to drink more than they might at your bar. So you're going to see, I've personally seen people, we'll get people who have all sorts of opinions about Lady Justice who will, be, 6 samples in on a beer festival and like tell me what they really feel, right? And I mean, it's not always sexual harassment, but right, like boundaries tend to get blurred at these events where we're having fun, we're drinking, we're joking around with people. That's a really easy place for a line to get crossed pretty quickly. And if you go back
Right.
and I remember there were very specific examples when Brianne was sharing on her Rat Magnet account that was like, I was at a festival and so cornered me. And I've seen that happen at happy hours, at conferences where somebody's trying to sell, this happened to my wife. Somebody was trying to sell my wife their brewery product and cornered her in a bar, right? Is that sexual harassment? I don't know, but it certainly it was harassment of some sort, right? It was unwanted interaction between somebody who had more physical boundary to put up to keep her where she is so that he could pitch the thing, right? So these things happen all over the place because the beer industry is an industry where we gather together, we drink, we have fun, but we have to be able to have those boundaries and know where the lines are drawn, and just keep them in our mind.
It is informal, and that goes to the totality of the circumstances. That goes to the court's analysis on whether or not something was wanted or not wanted. So, and I can't wait to get into that section. But in the case of your wife, that would be an example of maybe nonverbal, where he's trying to sell her something. So he's not saying anything sexually explicit, but one example of nonverbal sexual harassment can be eliminating that comfortable personal distance that you have that you expect. We all are aware of the social contract, and we know that if you get more than a foot close to me and I can really smell what you had for lunch, you might be a little bit too close. Okay. So speaking of those examples, and I've lost some formatting here, but speaking of those examples that you were talking about with respect to Rat Magnet, let me see if I can get that. Well, I've lost them, but these are all cutouts from some of those messages that Miss Ellen got from the Rat Magnet endeavor. And they include exactly what you just said, not just comments that are sexual in nature, but people getting upset that a woman owns the bar, or saying, oh, I thought that this place was run by veterans, as if, I mean, with the premise that women can't be veterans. And I'm saying women, but it's important to remember that sexual harassment can show up in all different kinds of ways, no matter your sex or gender. But as you'll see in the next slide, when we talk about statistics, 78% of 78% of the complaints or the charges that come out related to sexual assault and hostile work environment with respect to sexual-based discrimination are filed by women. So this is just an example that you can go out into the ethers and find hundreds and hundreds and hundreds, probably thousands of examples of all of these different types of sexual harassment. So as I was talking about, we see in 2017, 2018 timeframe, with the Me Too movement, you have huge spikes. And the reason that is because people felt more comfortable. They felt more confident with society's appreciation as a whole that sexual harassment and sexual assault do happen more frequently than we would like to admit. And now there's this national, global support and confidence building for talking about it. And so we saw a pretty large spike in 2017, 18, and 19 on the heels of Me Too with respect to that. Fell off a little bit, and then in 2021, so I don't have the 2022 and 2023 numbers. They haven't been released, but after 2021, when the brewing industry started to have some uptick in support for these types of cases, you can bet that those numbers do go up, particularly in certain states. Um, on on a quick note, or one quick note about these are statistics from the Equal Employment Opportunity Commission that generally investigates these claims. And we could have a different conversation about litigating sexual harassment claims as they relate to the workplace. But usually the first step is actually the internal complaint process, which we'll talk about. But then the first kind of administrative step outside of your workplace is at the EEOC. Between 2017 and 2021, the EEOC recovered almost 300 million for complainants on sexual harassment alone. Feel free to go ahead and double check that stat, but I want to say it was 299.8 million in recovery. So the categories of damages that we're talking about, in case you don't know, are back pay. So that's, how much the complainant would have made but for the employee's illegal actions. And this is typically employer's illegal actions. And this is typically when the employee, the complaining party, is terminated. So they're terminated for complaining about a patron or complaining about a supervisor, and then they're out of work, and so they have to find another job. They're having trouble finding another job, and they have to file this action. So back pay is one of the categories of damages, and so is front pay. Oftentimes you can get front pay depending on certain factors, including your age, your employability, your skill set, etc., and how long it took to find another job. Compensatory damages are damages that you all have probably heard of more than any of the other damages, which includes pain and suffering, any physical pain if it was an egregious or a violent sexual harassment or sexual assault, and then the pain and suffering that everybody in everywhere has heard about. Punitive damages are available. They're not always granted. But when we talk about some of the sweeping changes in state laws, the punitive damages is becoming more of a factor in courts' damages considerations, or it's becoming a little bit easier to get punitive damages. I'll talk about an example of that when we talk about the Colorado Power Act, and how if you keep an offender employed after determining that that person has committed a sexual harassment, and then they do it again while still in your employment, that could be grounds for automatic punitive damages. So that's under a specific Colorado law. I believe that Vermont, New York, and California have similar laws. And these are recent enactments. These are within the last 8 to 16 months. Pre and post judgment interest, those interests numbers do add up. A lot of times the EEOC case is pending for 2 years, and then you have a 1.5 year civil action, and all of those years are adding interest to the actual judgment. Injunctive relief could look like reinstatement. I have seen some relief in the form of apology letters, and training. So, and mandatory training for the people who were involved. So those are some of the other things that a plaintiff can ask for. Nominal damages, really there's no loss, but the complainant is looking for something tangible to say, hey, I was right. And then attorney's fees and costs. Under Title VII, you can shift attorney's fees. So these are some of the real costs of sexual harassment. When somebody, and I'm talking about the economic tangible costs. I'm not even talking about, well, I am talking about the pain and suffering and the emotional distress that comes with it. But the real costs to the particular person and to the establishment. Other costs, sorry, my changes didn't save with the coloring here, but you can see, you probably can't see, some of the other costs are loss of productivity, negative publicity, negative staff morale, high turnover rate. So that's costing the business as well when you have to keep training new people and paying people out who are leaving. Retaliation claims. Even if people are not exactly sure that something for sure happened, with those high turnover rates and the negative morale, they might think that something happened, and so they want to file their own claim and see. You have the greater potential for actual physical violence, especially when the leadership is not involved and acquiesces to a lot of the harassment that goes on. That can escalate. You have claims of favoritism, and there are some other ethical problems as well. What other costs, if we haven't already talked about them, Betsy, have you seen, or can you imagine with specific respect to the brewery?
Yeah, I mean, I've seen, fallout from Rat Magnet. There were breweries who had rescinded invitations from maybe prestigious competitions or festivals, or that goes along with sort of the negative publicity. But I saw, some breweries that were called out were asked to not participate in some stuff. And then, I mean, all of these are costs, loss of productivity. I mean, everything on here has a dollar sign that you could probably assign to it, right? So these are very big costs. And some of them might be pretty hard to recover from. Yeah.
Right. I think that's a huge one, that reputational harm, because you spend years developing a reputation for your brewery and for yourself. And, they say trust takes years to build, and in 1 second, one lie, one issue, it can be completely destroyed. And we see a lot of that when companies in general just completely mishandle harassment claims. Okay, so I'm going to try not to take up too much time with the legal framework, but this is my bread and butter, and I do want to provide the legal framework. We still have a lot to get through. We'll talk about the legal definition of sexual harassment, and then how to prove a case for the complainant. And then what you might be more concerned about is how to establish employer liability. Okay, so the legal definition, it's really what we talked about, unwelcome sexual advances, but it's specific to that person's place of employment. So if the harassment is tied to some type of benefit of the job, then it is legally under Title VII, then it's sexual harassment. What I want to stress is that the courts nor the EEOC want to create a general civility code. They specifically say this is not a general civility code. We're not telling people what to do. We're telling people what not to do. And there is a difference. They are not trying to explicitly control anyone's opinions or thoughts or speech, but they are saying, here's the bottom line. We want people to enjoy the benefits of work. We want people to be able to go to work in a place that's not offensive, so that they can have an equal footing in all benefits of the job, without respect to this characteristic that we're trying to protect. So there are two main types of sexual harassment claims that the court and the EEOC will consider. The first one is quid pro quo. That's literally directly tied to the benefits of employment. You have to have, the most egregious one is, you have to have sex with me or else I'm going to fire you. Or give me a smooch if you want this promotion, where it's kind of like gross and directly attached to a tangible economic, that's the key word, tangible economic benefit of the job. Those tangible economic benefits include termination or continued employment, reassignment, demotions, promotions, and things you think of when you think of solid pillars that impact that person's employment. Separately, we have the second type of sexual harassment, which is just an offensive working environment, a hostile work environment. So it doesn't necessarily affect whether or not you have a job, but it impacts how you have a job. If you are still nervous to come to work every day, if you cry in your car before you walk in, because the environment is so annoying and offensive, but you have to work there, and you haven't lost your job, you haven't been reassigned, you haven't been demoted, but it's to a level of so much discomfort that it's creating a hostile environment. That's the second type, and they do have different legal implications. A couple of other things to note, like I mentioned earlier, the situation doesn't have to be between members of the opposite sex. I have seen plenty of cases where someone is creating a hostile work environment based on a person's sexual orientation, especially in male-dominated fields, where you oftentimes have a general expectation of how that person should act, and you have somebody who's not acting that way. And obviously we have to be careful with how we describe these things, but when you're talking about a super masculine environment, like the trucking industry is one example, and you have somebody who is a more effeminate man, that person, when they get harassed, that is a form of sexual harassment. It can be between, like we talked about earlier, a customer and an employee, or between co-employees, or between different levels of the hierarchy. Did you have anything that you wanted to add to that, Betsy, about things that you have seen that maybe are not on this list?
Oh, no, I think all of these pretty much cross what would happen in brewery for sure. And we did have a comment from somebody who said they're reminded of a time when a drunk patron, an older Caucasian woman, decided she liked his beard enough to start stroking his face with no warning. So, right, like very example of a man having to deal with unwanted touch from a female patron.
Right, exactly. We have our what we normally expect from what we see in the media, but it happens everywhere.
Yeah.
Okay. So the plaintiff's case. So the plaintiff has to show that the attention or the comments or the touching was unwanted, and in order for the harassment to be actionable, under the federal rule and under most states, it does still have to be severe or pervasive. And that's severe or pervasive enough, like I said, to alter the conditions of the person's employment and to create an abusive work environment. And that's directly out of the statute. However, in order to be objectionable, it has to be both actionable. It has to be both objectively and subjectively offensive. So to a reasonable person within that area, and specific to breweries, it's got to be, if we're talking about a young woman, it has to be objectively offensive to other young women who work in that brewery, and subjectively, so to that particular person, and that person has to have actually been offended by it. So the key words are severe and pervasive, unwanted, objectively and subjectively offensive. Okay. I have to put an asterisk by severe or pervasive because that has been the standard since this section of the law was enacted. But in some states, namely Colorado, as of last year or earlier this year, that has changed. That standard has been stricken. The courts in Colorado have said, or the legislature in Colorado has said, it doesn't have to be severe or pervasive. It doesn't have to happen 5, 6, or 7 times in order for us to take this seriously. It can happen one time. And we still have other factors to rely on. We still have to consider the totality of the circumstances. But this saves those cases where there really is an egregious offense. And just because it doesn't happen 5 or 6 or 7 times and the person, kind of got away with it, that doesn't mean that you can't establish your prima facie case or your basic case. Okay, so that's under the Power Act in Colorado. I believe that California, Virginia, and New York have similar amendments. Okay, so again, one of the older cases, one of the first cases that really interprets this law is Meritor Bank versus Venison, and that case set the standard for what unwelcome is, and the fact that the inquiry is whether or not the sexual advance was unwelcome, not whether or not the plaintiff actually participated voluntarily in the action. That kind of sounds conflicting because you're like, well, if it wasn't wanted, then she probably didn't behave or respond voluntarily. But there are situations where the behavior can be unwelcome and that person still acts, or the plaintiff or the victim still acts. So what that case basically says is that the she wanted it is not a defense. The brewery or the aggressor cannot say she wanted it and use that as a defense to say, oh, well, she voluntarily participated, so she doesn't have a claim for sexual harassment. The question is whether or not the sexual advance was unwelcome. And unwelcome is determined by any indication that the advances are not welcome. Again, not whether or not it was whether or not the participation was voluntary or not. However, evidence of the employee's sexually provocative speech and dress is not per se inadmissible. So that means that evidence of how that person, the victim, was behaving and dressing is something that you can bring up to determine whether or not the sexual advance was welcome or unwelcome. And that's only in the context of a sexual harassment claim. The courts basically said, we appreciate that we have a federal rule, it's Rule 412, that says you can, when a plaintiff has a case or a complaint about sexual assault in the non-work environment, you can't bring up evidence of their past sexual acts to show that they behaved in a certain way in this context, in the present case. Under Meritor, in the discrimination case, in the sexual harassment case for employment, you can talk about that. It is relevant. And that, in my opinion, makes it harder for breweries and establishments. And I'm thinking of Hooters, for example, right? Where you have people literally walking around in bikinis. Um, and the court has to take that into context when you're talking about the totality of the circumstances and their general assessment on whether or not comments about the outfit, which is part of the uniform, is welcome or unwelcome. So the other factors to consider, this is not at all an exhaustive list. There are about between the federal and the state factors, there are about 15 to 20 factors that you need to consider. But the ones that I think go throughout are whether or not the advances were physically threatening or humiliating. We still have to consider the frequency. We still have to consider the severity and the unreasonableness of the interference with the work performance. So we talked about the two different types of sexual harassment. With quid pro quo, we're talking about employer liability now. With quid pro quo cases, that's where you do this in order to keep your job. That is mere automatic liability as a matter of law. Even if you, bar owner, did not know what was going on, that has a tangible economic adverse outcome because it's directly tied to the employment benefits. And this includes a threat. So if one of your supervisors threatens to terminate somebody if they don't give them a kiss, you are liable for that as a matter of law. And we have a case that says in this situation, the supervisor merges with the employer and his acts become that of the employer. So this is the risk you take when you hire a supervisor who maybe doesn't jive well with your ethos and who you don't think is going to be respectful of their subordinates. The harder case is with the hostile work environment. And I'm almost done with the legal section. I know it can be a little bit dry, but I think that this is probably one of the more important things that you as industry leaders and bar owners need to know. The more nuanced case is the case where the person is not terminated. They don't receive some tangible or economic adverse action, but there's still this hostile work environment. So courts used to consider whether or not the action fell out of the scope of employment. And I could probably do a poll here and say, how many of you include sexual harassment as an essential duty in your job description? And nobody would raise their hand because it's just not, you don't expect people to behave this way and to sexually harass people as a part of their job. So the courts used to say, no, that the employer can't be held liable for that because this has nothing to do with this person's actual duties. And so whatever sexual harassment was done, it's outside of the scope of employment, and the employer shouldn't be liable for that. They would make some exception if the employer received notice of what happened and then didn't do anything, and they just washed their hands and completely ignored the situation. So your acquiescence to certain incidents will be considered in whether or not you were reasonable in responding to an allegation. But Title VII, again, we're talking about the sexual harassment within the discrimination statute, or the anti-discrimination statute, has a broader interpretation of what is within the scope of employment. Title VII and the EEOC say as long as the action is a characteristic of the employer's activities, as long as you have come to expect this, even if it's not an essential duty, if it arises or is related, if it arises from or is related to the essential duty, the employer can be found liable. So a specific example is if you are in a warehouse and you work in a warehouse, the employer can expect that these 17-year-old dudes who frequently work in the warehouse are going to roughhouse. They're going to horseplay. And so in the case where an employee threw an apple and hit someone's eye and that person lost their eye, the employer was found liable for that, even though throwing apples was not at all in the job description for that warehouse. So I hope that makes sense, that the courts have determined that if sexual harassment kind of becomes or sexual comments in general become an expected thing in your workplace under the totality of the circumstances, and this is what makes it hard for breweries, the employer can be found liable for that. Okay. So at the same time, because they recognize that that is kind of difficult, they give employers an out. That is with your prevention. And we'll talk about prevention if we have time. Hopefully we have time to get to it, but we'll talk about prevention and how important it is to save your brewery. The out that the courts have carved for employers in this situation is both an incentive to establish a prevention program and for your employee to engage in that program, in that prevention program. So you have an affirmative defense. Basically, you can say, yes, sexual harassment occurred. I know it occurred because it occurs in breweries, but I have a policy and I have a practice, a regular practice in preventing and training around sexual harassment. I have a legitimate complaint process, and not just that, but also the plaintiff didn't take advantage of it. She didn't complain. She didn't, engage in any of the opportunities for remediation or mediation that we offer under this program. So if both of those factors are present, then you have an affirmative defense, and you can be found not liable for the sexual harassment. Okay. So yesterday, we're moving on to prevention now. Yesterday, Betsy and I talked about the importance of a handbook and how a lot of times these prevention policies are found in your handbook, but it doesn't necessarily equate to a handbook. If you don't have the funds to hire an attorney to draft your handbook from scratch, if you don't trust the templates that are available, you don't have to have a handbook, even though it is 100% recommended that you have a handbook. But some written policy that you can demonstrate that you follow to show that you're taking reasonable care, which is the standard and what the courts look at, that is going to be key for showing that you have taken some steps to prevent and intervene when you have a case of sexual harassment. Betsy, tell us what, maybe not verbatim, but what's in your handbook about preventing sexual harassment?
Our section is one of the very first in the handbook. So it's I think it's on page 2. It starts where basically we say we have zero tolerance for it. And then we list state law defining what state law sexual harassment is. And then how you go about making a complaint if needed and who you should reach out to. So for us, beer tenders can file a complaint to their taproom manager. If the complaint is about the taproom manager, they are directed to file with me. If there's a complaint about me, we have a leadership team at Lady J of 6 people. 3 of us work at the brewery full time and 3 do not. If there's a complaint about me, beer tenders and our taproom manager are expected to file a complaint against me to 2 of the other people on the leadership team. And so we just have, here's what happens here's what constitutes, sexual harassment. Here's what you do if you need a complaint. And here's the process we're going to go through once you file a complaint, so that there's never any question from the victim of what to do, what happens next, and what the results might be. So we talk about, we're going to do an investigation. If an investigation is necessary, we're going to do one. So the idea is that it's in depth enough so that staff understand the policy and the procedures, and that hopefully empowers them to know that we actually care about this. And then we also just talk about any other forms of, unwanted behavior, stuff like that. So it's all lined out there. I think it's about a page of information in our handbook.
Right. And we're talking about breweries that, we're not talking about Stone Brewing, right? Stone Brewing probably has a third party HR company that they enlist when they have a complaint like this. When you're talking about small grassroots brewers who just went after that entrepreneurial spirit and wanted to start brewing and open up their own shingle, they may not have the resources right now to do this third party checklist. What Betsy is talking about still hits all of those necessary elements that you need to demonstrate that you are taking reasonable care. In the case Farragher versus City of Boca Raton that we got this standard from, in that case, the employees could only report anything directly through their supervisor. So when their supervisor was the one doing the harassment, where's their outlet? They don't have one. Also, the city never gave them the sexual harassment policy. They gave it to everyone else in the city except for the lifeguards. So when the employee doesn't have access to higher management, when they don't have access to the actual written policy, and when the supervisors have so much power over the subordinates without them having any other outlets, in that case, the employer was not able to make an argument with a straight face that they cared, or that they implemented any procedure at all to effectuate a legitimate complaint process. So it doesn't matter what size you are. I hope you heard how Betsy says, if the complaint is about her, it's written down that the direct contact information that her employees can go to outside of Betsy. And the same thing with the immediate supervisors. When you have that level of access to higher management and to someone other than the person who you have a complaint against, that is what a court will say, okay, that's probably more reasonable than not having that at all. So other things to keep in mind, keeping track of the conduct. When you have an actual investigation and a true complaint process, it doesn't have to be super sophisticated, but it's got to be something. And equal employment, I'll just say that equal employment officers, they actually have a list of what they check for when they're looking at your proper reporting and your prevention program. They're looking at whether or not you've published somewhere accessible to the employees the actual complaint processing procedures. Does that complaint processing procedure tell the victim, one, that your complaint has been received and we're going to look into it, and two, what the investigation entails, who we're going to talk to, and the specific questions that we're going to talk to you about, and when our results can be expected. Are you offering them the appropriate disclosures? Are you letting them know what the EEO policy is? Are you letting them know that if they need any kind of auxiliary aids or if they need a language service in order to fully participate in the complaint process, are you making sure that they have those resources? If you do have an attorney, make sure that your attorney is giving the Upjohn disclaimers. Make sure that the attorney is letting the person know, hey, I'm not your attorney. I represent the brewery. If you want somebody here to represent you in this process, feel free. make sure that they do have those. And if you have an attorney, your attorney should know that, to just make those disclaimers. So with the current state of the laws, we do have some criticism. What this does is it forces the victim to go through the internal complaint process of their employer first. And I apologize, Andrew, we're probably going to go 5 minutes over, but I think I do want to get into some of these examples. Privatization of sexual harassment claims, and it creates this situation where if you don't go through the internal complaint process, it makes it seem like you didn't try to mediate your damages, and all plaintiffs have an obligation to mediate their damages. So that is why you have some of these other sweeping changes that have come after Me Too, and specific. You might, if you haven't already, you might start to see some specific changes within the regulations of the beer industry itself. And I'm not sure, Betsy, if you've seen anything like that with your own training and changes to your regulations about reporting sexual harassment. If you have, feel free to step in and put those down. But basically, you have things like the Colorado Power Act, where it reduces some of the barriers to actually filing a claim and being successful on your prima facie case. And more change is expected. So the takeaway is just to consider the reasonableness of the brewer's action or conduct in trying to prevent and correct the harassing conduct. This is what the court's going to look at, and the reasonableness of the employee's conduct in seeking to avoid harm. So that's the best balance that the court has struck so far. Man, we talked quite a bit yesterday about ethos. I want to give it over to Betsy to talk about the ethos of her bar, what zero tolerance means to her, and how it shows up in her place at Lady Justice.
Yeah, I mean, basically what I talked about with Danyelle yesterday is being able, if you set an expectation that sexual harassment is just not tolerated, people will live up to those expectations. And the people who choose not to don't need to work there anymore, right? And so what we talk about is training, just like we do tips training. We also do sexual harassment and assault identification and prevention, bystander intervention, all of that, for the safety of our employees and also for the safety of our patrons. And so just having that be a part of your company culture that you talk about regularly will really help, because it starts to let your staff know that you care about these things. And if something does come up, they're more likely to trust you enough, trust the company culture enough to actually say something and make a report. Because once these things are reported, you can actually start making changes that makes your workplace better for everyone. Makes it more efficient. People are happy to be there and work there when they're not being harassed. So there's a lot that adds up in terms of, just efficiency in dollar signs. You want your staff to be happy. You want them to enjoy where they work, and you want them to be able to work in a place where they're not being harassed. So if you just set up that expectation in your culture, you'll see changes happening where people will start to think on big and little scales how to recognize the behavior and what changes need to be made to stop that behavior if it's there. And so we just do these regular trainings. We have, when you get SafeBars certified, if you go to safebars.org, you can learn all about getting certified. You can actually get a certification to hang in your brewery. So that hangs above our tap line, pretty central to where our customers are, so that it's just a part of the tap room ethos as well. People have a visual representation to understand that we take a respectful culture seriously. And it can be difficult if you haven't talked about this with your staff a lot. If you have a small staff and think that you don't need to talk about it, you should anyway. And it can start with just simple trainings. You can just say, I'd love to do a SafeBars training with you all. put in your calendar, this is when it's going to happen, right? And so you can get resources from Safe Bars on how to do that. I know CBP has resources. The PACT Initiative is a good free, the PACT Initiative, that's a partnership between CBP and safebars.org. Free toolkit for you to have a statement against sexual harassment, and also some free resources of steps to implement it into your brewery. So you can start small, and then as it becomes just regular conversations through your workplace, you'll see that people will change their behaviors and also be able to talk to you a little bit more about experiences that they're having.
Great. Depending on your ethos, that zero tolerance may change. Again, the rules are not a civility code. They set the baseline, and then you can decide how much more strict you want to be with those basic principles, and that's going to change what zero tolerance means to you, whether it is one instance or whether it's saying, okay, this happened last week and it's happened again, or this happened last month and it's happened again. We need to take a more serious approach to handling this with this particular employee. Again, if you're in a state with some of these laws that are changing, and there is a claim filed against a particular person, you have to consider the future impact of that on your bar. If that person, same aggressor, does something again, you might be liable for punitive damages in that respect. So we've talked pretty a lot about prevention and intervention. I think that Betsy has certainly shared some of what I would consider best practices. The last thing I want to really quickly talk about is support. So make sure you have a plan in place. Look around your community and whether or not there are sexual harassment resources outside of your bar, and consider your obligation to sequester. Again, some policies will tell the person who has been accused, that they might need to take leave, paid or unpaid, until the investigation has been completed. And if the allegations were not true, then you might have separate consequences for the person that made the false allegation or made the claim that was not founded on anything. So you have to know what you plan to do to support your staff. But I appreciate that you may not be able to sequester or put somebody on a paid leave. And Betsy, why don't you tell me what you were talking about yesterday with respect to that and small breweries?
Yeah, I mean, Lady J's a small brewery. We have 9 staff, a majority of which are part-time beer tenders. And if I had to put my tapping manager on a paid leave while we investigate, that would be a huge knock to the bank account, right? Because then I'd have to assumingly be paying somebody else to do that job. So I'm paying 2 people to do one job. And so, what we talked about yesterday was if you can have a plan in place ahead of time, just like you do SOPs with your brew house, checklists for your taproom staff, before, for opening and closing, have a plan in case this comes up, so that you're not scrambling, so that if you decide that your brewery does want to do paid suspensions during paid leave during investigations, make sure you have the money to be able to do that, and the resources. If you can't, then figure out a way that you're going to be able to do an unpaid leave and also fill in those person's job duties. So just know what decisions you're going to make. Write them down so you have them, just like you do an SOP, so that when you need it, you're not scrambling and making, last minute quick decisions that you might regret later or might not be able to pay for later.
Right. And depending on your size, you might have to be creative. If you have 2 managers and 1 complainant, maybe it looks like a change in the shift, in the scheduling of shifts for a while, or permanently, depending on the results of the investigation. So We also talked about that would be a physically supporting a victim, but we also talked about you know, trying to support the victim even before some of those practical considerations come into play. Be mindful of how you're talking to the person who has just come to you with this vulnerable thing. They're already nervous about reporting. They're already not sure. They already don't want to ruffle any feathers. How are you going to respond to that person? Of course, in your investigation, because of how the court see this, you might ask them, okay, well, what was everybody wearing? But that's not the first question that you ask when someone first comes to you. When someone first comes to you and says, hey, I really have this issue, I'm feeling vulnerable, this happened, you know, what's the next step? Be mindful of how you communicate with that person. You don't want to just say, okay, well, what were you wearing? What did you do? What did you say? Because then you're getting into some of that unhelpful, some of those unhelpful interview uh, tactics. So I would love to hear from Betsy on some of the encouraging things, the holistic, and there is actually a word for it. It is called trauma-informed interviewing. Some of those questions that you might ask Betsy when you first have a complaint.
Yeah, I mean, for us, it's, you know, if a victim has a complaint, it's, you want to approach it with care. You want to be clear about what you need in order to do a report. And you also have to understand that a victim who's gone through a trauma of harassment might not be able to recall the incident very clearly right away. It might take them some time to be able to report fully what happened. So patience is really key. The ability to listen with care without judgment is key, especially in these initial reports. But you want to be able to have a clear understanding of what happened so that you can document it correctly. And to be able to do that, you really do sometimes have to have some patience with it. And then also offering, if needed, resources and support that might help the victim if they need medical or emotional care. There are all sorts of likely local resources that you can look up that you can offer to your staff. As part of our Safe Bars training, they sent us a whole list of at least national resources, and those are taped to the wall inside our brew house so that beer tenders can access it easily on their own if they need to, you know, without having to ask me for those resources too. So maybe having them in a place that's easy to find for your staff without you having to like physically hand them, you know, a flyer or something like that might be helpful too for their own privacy.
Okay, so that's a wrap with that. I think just make sure that the person who's coming to complain, regardless of whether they have a claim, that they walk away feeling heard and that something's going to be done if it's at the very least an investigation or a meeting, as opposed to it being a complete waste of time.
Mm-hmm.
Okay, so the last thing, the very last thing, I promise, Andrew, is just the role of leadership in all of this. I think find a brewery that you like how they do things and try to emulate them and their good examples. And we've talked about a lot of these: train and document. You set the standard, so you are the one who has to communicate what the ethos of the bar is. And a huge one is don't ignore these issues when they come up. You have to address them. Even the minor ones. Again, you don't want to get into the habit of micromanaging. You still want to run your bar. You still want to provide your service and your product, but don't ignore these things. It's a part of protecting your employees, protecting yourself, and protecting your business. Lastly, empower your staff by supporting them to walk away from a harassing situation and to report it. Okay, so if there are any questions, I'm sorry, we won't be able to get to them. We're already 10 minutes over, but thank you so much. Betsy, especially, I really enjoyed hearing your opinions and the way that you do things both yesterday and today. Like I mentioned a couple of times throughout this session, I think that you do employ some of what I would consider the best practices. And if anybody has any questions, make sure to call Betsy. I know you all know her. Thank you so much, Andrew, for your technological services, and to the hosts of this session. And that's it.
Thanks, Danielle.
Thanks.